Hello, my name's Dale Adams of Planning Ahead of Time, and on this week's Pack Chat, I'm talking with Jay. Jay, would you like to introduce yourself and tell us what you do?
Hi there, Dale, and thank you very much for the opportunity to support you guys. My name is Jay Parmer. I'm a partner at a firm called Paradigm Wills and Legal Services. We are will and estate planning experts. We're based in Leicester, but we cover the whole of the UK. We specialize in wills, trusts, lasting powers of attorney, probate, and inheritance tax planning. So anything to do with end of life, to make those arrangements, that's what we get involved in. We work with a lot of other businesses, including law firms, financial advisors, insurance companies, to be able to support clients with those kind of needs as well. Because we don't specialize in those, but we have those affiliations with those kind of companies so that we can support our clients moving forward.
Okay. So at what point would you suggest that people got in contact with you? What point in their lives? Because I think a lot of people think they should be a lot older when they start considering planning. I personally feel they should be quite young. So what's your view?
My view is exactly the same. The wills are created for anyone from the age of 18 onwards. So from the age of 18, that's when you should start considering. Now, a lot of people at the age of 18 probably don't have any assets, those sort of things, but they would have simple things like bank accounts. Now, as long as their parents are alive, if you don't have a will, then the bank accounts, those sort of things will go straight over to the parents at that point. If you don't have parents, but you have siblings, then it'll go automatically to siblings. However, if you don't have siblings in place, you don't have parents around, then you may want to start considering a will, because you want to then be able to dictate where your estate is going to go after you pass away. Whether it's £100, whether it's a couple of £1,000,000, you always want to be in control to ensure where that's going to go. Some people do have the attitude, well, when I die, whatever happens, happens. But you will have friends, you will have families that you think are worthy of having an estate passed over to them, and it will be a bit of a game changer for them. It'll make a difference to their lives. As an example, in our will, me and my wife have created a will to ensure that our children will inherit if we were to die. However, if all four of us died, we have to think about where does our estate go at that point. So we looked into our family, and we looked at families that were not as privileged and didn't have much. And if we could leave something behind for their children, that would be a big game changer for them. And that would ensure that their children would have hopefully a successful future financially and have less worries. And those are the kind of ways to think about it. People are always asking me, when's the best time to create a will? Well, it's right now, because one thing that you can't be certain of is what day you're going to die, when you're going to die. And that's something that you can't guarantee. So people are always, yeah, I'll get round to it, I'll get round to it. But when do you get round to it? Sometimes people leave it too late, and there's little that we can do for them at that point. And it's good to have it done when you've got full capacity, mental capacity, to make sure that you're in control, you can make those kind of decisions. And if anything changes in life, at least you've got some provisions in place rather than nothing in place at all.
Yeah, well, this week just gone was with a client who's 73, first time doing a will.
Yeah.
So that was quite interesting. And again, it was talking around the topic of what do you have happen? What if the person that you're giving it to isn't either capable of taking on the responsibility or doesn't want to take it on because they're a young person. So we've gone through that. But also with regards to children, my children are a bit older, and they're in their early 20s, but I've spoken to them both so that they have wills, because at the end of the day, they do have cars, they have possessions, they have lots of lovely clothes.
Yeah.
And it's things like this. It's what would actually happen to that and what would they want done. So, yeah, I think even though they are young, it's still so important. And I also think, for me, obviously, I look at planning ahead of time sort of from an emotional and spiritual perspective as well. So it's ensuring that they've got these things written down and known, so that obviously the people that they want to have their belongings, but also to have some messages from them, have got them available to them. So I do agree with you completely. And again, for my will, I have a wipeout clause, because I travel with my family quite a lot. And when we do, you think, yes, if something happened to us all, whether it be in a car or going on holiday, etc., then you do need that option of what happens then.
Mhm. Yeah, you know, these are kind of conversations that you need to have. And when we're dealing with our clients, we'll always have a client that will come to us. They have an idea of what they want to put into their will, but they don't seem to understand it as well as what you can actually do with those. A lot of companies that we've spoken to previously, the class as what we would class as order takers, where they will just take some basic information from the client and then create a will. So there'll be name, beneficiary, executor, and here's your will. Whereas what we would do is we would spend a lot of time with the clients, providing a level of service where we give some advice, we give some guidance. We will never make the decision for the client of what they need to do, but we will give some guidelines around, okay, if you were to do what you're planning on doing, these could be the potential repercussions. So there's some pros, there's some cons to it. And this will open up the floodgates for them to then ask further questions and will help them to design a will that is most appropriate for them. In addition to that, we will then look at trust planning with the client to try and see if there's assets that need to be protected. It could be that their children are quite young at the moment, and if both mum and dad did pass away, they could have a trust set up so that something simple as a discretionary trust to be able to protect the children's assets until they're old enough to be able to manage them. Now, it could be that they're quite young when mum and dad passed away. Yes, there's guardians looking after them, but they're missing out on the love of mum and dad. They go off the rails, they fall into the wrong crowd. Now, while you're alive, you wouldn't fund any of their bad habits, i.e., them going into drugs, those sort of situations. And you want to have that level of control after you pass away. So by having something in the form of a discretionary trust, you can have that kind of level of control after you've passed away, and making sure that your children inherit at the wrong time. Sorry, at the right time, making sure that making sure that they don't inherit at the wrong time, but they inherit at the right time, making sure that they have access to the funds, but only when they're able to manage it themselves. Up until that point, they'd have aligned trustees to be able to manage it on their behalf up until that point. And the trustees would have full control until the children are ready to take over.
I think that's the important bit, Jay. It's actually speaking to people about the what ifs and so it's, but what if that happened? And so if it does, what next? Because as you say, just the first will that I was given when my mum died was a copy of a will, and it literally said everything to my husband, cremated. Yeah. Honestly, that was it. And it was obviously printed off the internet. It probably cost maybe £20. And I initially was actually giving that out when she died, because I hadn't realised until then, went to the solicitors, that there was one that was much more in depth, thankfully, but also had a trust element attached to it in relation to their property, to make sure that, again, if something happened to one and then the other needed to go into care, that their assets were protected. And people often will say, well, a will's going to cost a few £100. I know in that particular occasion, it cost them over £1,000 to have that will done. But the amount of money that will protect now, should my dad go into a care home, when the care home fees are £7,000 a month, that will protect so much money. And again, I think the problem sometimes is people paying that up front, not necessarily realizing that the monetary value it has.
Yeah, these are the most important documents that anybody's ever going to create. There's no point creating a lot of wealth, properties, money, those sort of things, if you're going to cut corners right at the end. Yes, there are things like free wills that you can just download off the internet and create that will. But you've got to ask yourself the question, do you actually know what you're doing when you're completing these wills online? For an example, I always use the example of a dentist and a builder. So if you want to get your tooth pulled out, the dentist can do that, give you anesthetic, and then pull your tooth out. You can go to a builder, they've got pliers, they can pull that tooth out for you, but you're always going to opt for the dentist. Why? Because they're a specialist, because they know what they're doing and they're going to do it correctly. And in that same way, we would do exactly the same for the client. Yes, we are going to charge because there's a service that we're providing and we're running a business at the end of the day, but we do care, and we want to make sure that the clients are provided with the right level of advice and provided that kind of information. We came across a story just recently where I was in a networking meeting, and the builder that was actually there at the point, he had a friend whose mum had gone online, created an online will. It's a free will. She saved herself a hell of a lot of money. Now, the aim was to ensure that 85% of the estate was left to the son, and then the remainder was left to a charity. However, the mum had completed that wrong. She left 85% to the charity and the remainder to the son.
Wow.
Now, it's a legally binding document. She had it signed, she had it witnessed. So for as far as anyone else is concerned, that was what the mum's wishes were. But it sounds like with the relationship that he had with his mum, that she would have wanted more of it to go to him. So they've created a will on that kind of basis. It hasn't come to us, but the dilemma is now for that son, does he contest that will and contest it against a charity and go down that situation? And there's a chance that he could be proven wrong on that yes, it was purely for the charity, and that's what mum's wishes were.
Yeah, but you see, you can also put in a non-contest clause, can't you? Where you can actually say, if anybody does try and contest this will, they're automatically written out of it. Which again, I think you've got a family where you know that actually your children or siblings are likely to argue over what you're leaving. That's something else that people can put in to sort of protect their actual wishes.
That's right. So part of the segment of wills that we cover with the clients, is there anyone that you're looking to exclude from the will? So we can do that. Now, sometimes you will find that there's been family breakups. So it could be that they've fallen out with their son, as an example, and they may want to exclude a son. So we would do a lot of extensive work with the client to try and make sure that these are the right reasons that they're looking to do. It's not just a little tiff that they've had and that's why they're cutting them out. You know, we'd do some extensive conversations with them and then look at ways of how to make sure that if we are excluding them, the best way to exclude them so that even if they did try and contest, their wishes are going to be abided by.
Yeah, I mean, that in itself is such a difficult element. And of course, I've actually experienced somebody where the mother then lost capacity. And so it's now a debate over when the will was changed to exclude one of the children. Did she have capacity at that point? So I also understand that you can, again, confirm, I think, as a solicitor, or that somebody does in fact have the capacity to state, no, these are my wishes. I have full capacity when I'm completing this to say that I don't want that person included. Is that correct?
Yeah, that's right. You sometimes it requires investigation. So it could be that you need to get health records to try and find out what the health history was like. The doctors would have that, NHS would have those kind of information to say what capacity was like for that client at that up until that certain point. If we ever come across a client where we're concerned at any point, we would ask them to get a capacity report done from an independent company. We work with various firms that will do capacity reports. They would, you know, the client would have to spend a couple of £100 sometimes to do that. Sometimes it doesn't cost that much. It depends on what's being required. But a capacity report will be important for a firm like us where we're unsure about the capacity of this client, especially if you've got the son or daughter ringing us up and saying that, well, my mum's losing it at the moment and she's trying to change the will. And I go, okay, that's fine. We need to have a conversation with her first. Let us have that conversation. We determine that. If something doesn't seem right, then we'll get that capacity report, because you know that the children are going to contest whatever the mum has created. Whether she's got capacity or not, they're going to try and use that kind of angle. So by having that capacity report, it would safeguard not just only us, but that client's wishes as well in the way that they want to create it.
Because this is what's so important. In our living capacity lives, we make choices about ourselves and what we want to do all the time. And I think for me, the part of planning ahead is to make sure that when you actually get to the point either you don't have capacity or that you've died, that your wishes live on. Sort of even when maybe you aren't able to voice them, or when you know you're no longer here to organize them, that you've actually got everything in place. And talking to professionals, as you say, you know, you're absolutely right. You can get that advice from somebody who knows elements of it. I mean, I'm not a specialist in any of that. I can do the consulting where I actually speak to people about what are your wishes, what's going on. But there gets to that time when I say, okay, you need to speak to a solicitor, a lawyer, a will writer, whoever they actually need at that point. Because from my side, it's more looking at what do they want as a person, as say, with the emotional side and spiritual side of it as well, and how they want to be cared for, and then how to have the conversations with their loved ones. about what they're going to do, because it's all right coming to yourselves and changing a will drastically. But sometimes those conversations need to be had first, as they in themselves create conflict after somebody's died, when suddenly it comes to light. And then where there wasn't a conflict between siblings, the conflicts can arise because one suddenly finds out that they've got more, or another sibling. Again, it's another scenario I'm aware of, where after the death, that was when it came to light that it hadn't been shared equally. And
there was a story just recently that was, there was a story that I just read recently. My wife actually sent it from the local newspaper, and the story was there's a grandfather near to the end before he passed away. He changed his will from leaving it to his children and to his grandchildren, because none of them were spending any time with him, especially while he was in hospital. No one cared for him, no one came to see him. And he decided that the people that are around me before I die, they're the ones that have been around me all the time. So I want to leave it to them. And that was his brother and his sister. And they used to come around and they used to look after him. So when obviously the grandfather passed away, everybody's waiting for the will and expecting their inheritance. It was £500,000 of an inheritance that's coming their way. And then they found out that they weren't getting anything. And it was his brother and sister that were actually going to inherit. So the children had actually taken the uncle and auntie to court to contest the will. The judge actually overruled it and said that the brother and sister are actually entitled to it. He goes, it's right. The person had capacity at the point. He detailed why he was excluding the children and the grandchildren from the will. And the main reasons were that they didn't care for him, they didn't spend any time with him, and for that reason alone, he's going to cut them out of the will and leave it to the people that were supporting him. They looked after him, they spent their own time and money looking after him, and it was only right that they would inherit at that kind of point. So these kind of things would happen. When it comes to capacity, if the client doesn't have capacity, a will writer or a solicitor will not take the instructions from them. They shouldn't be taking instructions. But we do hear these kind of things happen, because what happens in certain situations is that children get involved and the children are talking on behalf of the parents, trying to make it out in the way that it needs to be. Any respectable firm will avoid those kind of situations and will just flatly decline to take the case, because that client has to have capacity. They need to be able to express the decisions of what should happen after they pass away.
Yeah, well, everything you're saying makes total sense, and I do hope that people maybe come forward to speak to you about it if they want information. I know I'd love to also have a conversation with you about LPAs, but we're out of time for this one, and it's been mainly focused on wills, but I do think there's information there that will be very important to people to hear. So how do they get hold of you, Jay?
Sure. So they can contact me on my mobile number, which is 07976 851 552. Or I can leave you.
Can you
Sorry,
just,
yeah.
just a little bit slower for people, please?
Of course I can. Of course I can. Okay, so it's 07976 851 552. What I can also do is leave you with my contact details, and you can share it on the handles when you're sharing the video, and people can then just hopefully click onto that and then connect with us. I'll leave my email address and our website address details as well. We offer a free consultation to our clients as well, so we don't charge to spend that time with them, because I think it's important that the conversation that we're having, that people aren't clock watching and worried about how much is this costing them at that point. So we spend that time, give advice, guidance, and then we leave our clients with the recommendations so that the clients can then decide on what options they want to go ahead with. And that's the way that we operate with our clients. There's never any pressure with us. We cover the whole of the UK, so we can either do face-to-face visits, we can do it via Teams, online, or we can do it over the phone, or they can come into our offices and then we can have the meeting over here.
Okay, and your offices are in Leicester, you said?
We're in Leicester. We've just recently opened up an office in London as well, so we've got those details as well. So again, in the handles, I'll share with you all my contact details, and then if the clients want to arrange those kind of appointments, we can try and accommodate those.
That's lovely. Well, thank you ever so much for taking the time to come on this chat with me. And,
thank you very much for your time as well.
No problem. Thank you very much, Jay.
Take care. Bye.